Jacob Ayler of the Law Office of Riley and Ayler PC, and today we are going to discuss what to do in the state of Indiana if you have a child out of wedlock. And we're also going to discuss the don'ts of what not to do if you have a child out of wedlock. But first, if you have any questions about this or any other legal topic, I invite you to please reach out to me, give me a call, shoot me an email. My phone number is 219-866-3435. My email is jacob@michaelriley.lawyer. I love to just chat with folks, and I'm more than I know lawyers have this terrible reputation of sending people a bill for things like that. I am always happy to talk to people because if I can point you in the right direction, generally that's going to help you, and it allows me to get you the information you need so you can make a decision. But now I want to discuss what to do and what not to do if you in fact have a child out of wedlock in the state of Indiana. So, as some of you may know, in the state of Indiana, if you are not married when you have a child, your rights are different than if you were married. For example, if you are the father of a child, you are not presumed to be the father of the child unless you establish what is called a paternity action. A paternity action is where you go to the court and essentially tell the court that you are the father of that child and you wish to have your rights established. This is important because what often happens is people are in a relationship, they live together like they're married, everything's going fine, there's no problems, and then one day, for whatever reason, the relationship ends, and I get the phone call from the frantic father that says, hey, my ex-girlfriend has my child and she won't let me see him. I get that phone call every week. What you do is you want to contact a family law attorney who can explain your rights and who can file the appropriate pleadings with the court to establish paternity. That can be done by admission, and what that is where the mother and father go into court and they admit that the father is the father of that child, and then you would establish rights of visitation, child support, legal rights, legal custody, so that if you're the father, you have a right to see your child, you have a right to make informed decisions about your child's medical care, schooling, educational issues, religious issues, and that the mother of that child does not get to tell you that you don't get to see the child. On the other hand of that, one thing not to do is don't take matters into your own hands. I see so many terrible cases where the father gets upset, goes over, tries to take the child away, or takes the child and doesn't return the child, and the police get called. And the reason you don't want to do that is twofold. First and foremost, that's very traumatic to a child to be pulled back and forth between the parties. But two, you also have to remember, if you don't reach an agreement, all of this information is going to go in front of the court. And if you're trying to show a judge that you are a good parent, that you're a stable parent, that you are the parent that should be given custody of this child, it doesn't look very good if you have to explain why you essentially kidnapped your child. That doesn't look good for you at all. The second thing that you should do is establish child support. And this goes on both sides. Many people misunderstand that child support is for the child. It's not for the mother or the father to use as their own personal funds. But what that does is it allows you to have a definite dollar amount that you're responsible for or should be receiving every week, so that it's very clear what your responsibility is for supporting that child. Another do is you want to have a defined visitation schedule. What that consists of, and I would invite you to look at the Indiana Parenting Time Guidelines. That is a basic template. Many times people deviate from that, and I'll tell you what every judge will tell you. The law wants moms and dads to work together to work out a schedule because that's what's best for the child. The purpose of the Indiana Parenting Time Guidelines is that is a default rule of what visitation should look like if the parties can't agree. And it's important because that is a minimum amount you are guaranteed in the event the parties don't agree. Another thing or I guess what I would add as a don't do is don't do what so many people do, where they go out and they start bashing the other parent on social media. This only leads to problems. It only ends up in court. And I always tell my clients, don't put anything on social media when you're going through a custody dispute that you wouldn't want read back to you in front of a judge. Especially if you have older children, if you have children that are middle school, high school age, that are able to see this stuff. It only alienates that child from the other parent, and it makes you look like you're putting your own needs in front of your child's needs, which is never going to play well with a judge. Lastly, define. I always recommend to clients, define your rights in a written agreement. A lot of times people will be very loose with the way that they reach a paternity agreement. And what happens is that works for as long as the parties don't want to exercise their rights. But what happens is the mother or the father gets into a new relationship, a new person comes into the family, and now that laid back agreement is not effective because it doesn't specify what rights you have as far as visitation, what you're permitted to do as far as making rights decisions on education, medical expenses, those sorts of things. And so I generally tell everyone to have a detailed, specified written order with the court, because if you want to allow the other party to have more time of visitation, there's nothing that stops you from doing that. But at a minimum, you need to have those guidelines and those designations written in a very clear, concise manner, because if the other person starts withholding that visitation, now you have the ability to go back to the court. Again, if you have any questions on establishing paternity, what the process looks like, what the law says about this sort of thing, I ask you to give me a call. You can reach me at 219-866-3435. Until next time, have a great day.